So we are live now. I'll
Yeah.
just confirm whether people on YouTube can see us. Just a second, sir. I think there's some issue. Yes, I think we're visible now. Just a second. There's some sort of a lag on YouTube, so it may be one of our internet networks, could be mine as well, and we're audible too. So I guess we'll start now. Just to introduce everyone, hello everyone. My name is Srihari Mangalam. I'm one of the directors of the Constitutional Law Society at NUJS. And welcome to everyone, of course, to a session on sedition laws and their status in India, which is organized by the Constitutional Society at NUJS. We have Mr. Prashanto Sen as the guest lecturer for our session today. Mr. Sen is a senior advocate at the Delhi High Court and the Supreme Court of India. He holds a bachelor's degree in history from the prestigious St. Stephen's College at the University of Delhi. He completed his LLB from Delhi University and went on to achieve a BCL from the University of Oxford. He has worked with Amarchand Mangaldas and at the chambers of Dr. Abhishek Singhvi. He established his independent practice in 2004 and was designated a senior advocate in 2017. We are very happy to have you with us, Mr. Sen. Moving ahead. So we have the session will also be moderated by Mr. Anshul Dalmia. Anshul is a 2022 graduate from NUJS and has previously served as a director for the Constitutional Law Society. He's currently working at Khaitan & Co. as an associate. I would request Anshul to take over now. Thank you so much.
Thank you, Shri, for having both of us and for these kind words. It's truly an honor for the Constitutional Law Society and NUJS generally to host senior advocates in. And I'm sure that all of us joining through this online platform will benefit from his views and opinions on the topic at hand, which is the desirability of sedition laws. Being the moderator, I have a pretty simple job. I'll just give a brief context in hand and kind of introduce the topic with us. So currently, we understand that the Supreme Court, headed by the Chief Justice, has stayed the application of sedition laws in the country. A direction was given from the apex court to all officers and executive agents to not register any cases on seditions, and thus essentially has made the provision of the penal code kind of redundant, in my opinion. This direction came despite the government kind of assuring a systematic review of the laws. While some scholars, senior advocates, and lawyers have lauded this judgment, considering the rampant misuse of law. However, some have raised their eyebrows, contending the separation of powers and the role of the court to stay any provision, right? So they have contended that the means should have been legal to, in the end, to justify the ends. But sort of, this discussion on sedition laws becomes extremely important both on the constitutional as well as the criminal forefronts. Because as we all understand that sedition laws are a product of our colonial history and they were added to our penal code by the British government to ensure allegiance and obligations and to ensure that some of us and all of the people governed by the British crown remain kind of obedient to the crown at hand. Right? Here, however, even after independence, we can see that the provision was retained by every single government. The criminal sanction has thus been used to prevent any secessionist movements and to prevent the breakdown of a national security, community, and territorial integrity. While these laws have kind of been conflict with our fundamental right to speech, we can understand that the constitutional validity of sedition was upheld by a five-judge Supreme Court bench in the case of Kedarnath versus the state of Bihar. Right? So I think this kind of, and in order to contextualize our discussion at hand, it's important to bring this entire debate in the contemporary times. Right? Here we can see that it's important that in the talk which we have, we discuss both the prongs. And if I could just rephrase myself, I think it's important to discuss both the heads of this snake itself, right? Which is to understand the need of having, say, sedition laws in India, which is to understand the meaning, the concept, And secondly is to discuss the execution of these laws, right? Is how the state kind of comes into the picture, deals and discusses and kind of executes the sedition laws. I think that also needs a discussion while we kind of want to have a holistic elaboration on this very topic itself. You know, we've in the recent times we've seen several cases. We've seen the Vinod Dua case, the Disha Ravi toolkit case, the Umar Khalid Kanyakumar case, and I think, in my opinion, one of the cases which kind of even led me thinking as to whether sedition laws would be required was the Bangalore case where a teacher was taken in for a play for having a satire on the anti-CA movement. Right? So I think with this sort of basic background and in this backdrop, I would hand it over to Senior Advocate Sain for kind of discussing primarily the need, the requirement of having sedition laws, and if there is a need, so how do we kind of go ahead with proper execution of the same. Also, just a caveat, right? As even Shri mentioned, please ensure that you put your comments in the chat box itself, and at the end of our session, we'll be taking it over and discussing it. So over to you, sir.
Thank you very much for first of all for your kind words, and then also for the setting out the framework of the talk which is to take place. And my submission is going to be that sedition law section 124A is archaic. It is not required here. It does not need to be on the statute books at all. It should have been thrown out a long time back. And I will be therefore elaborating on that. Why do I say that? Now, the important thing to be kept in mind, you talked about the case before the Supreme Court where the stay was granted. And in that case, the government said that they are contemplating removing this archaic law. The strange thing to be kept in mind is that even 75 years ago, Nehru had said the same thing, that I want to get rid of this law as quickly as possible. But that did not happen. And therefore, the first point which the two important points which I'd like to make is, first being that governments in power are very, if not reluctant, maybe I can say lethargic to give up Section 124A. So it is not something which governments are going to easily give up, irrespective, as you briefly mentioned. But I'll kind of emphasize that point a bit more. And the second thing which I'd like to point out is that the interpretation of this section by Kedarnath has left a lot to be desired. It leaves a lot of subjectivity open, which opens it to misuse. And even though there are progressive judgments of the Supreme Court on sedition, it still enables the misuse to take place. So that's the second reason why it should be removed. Archaicness, and second, its potential for misuse in spite of some progressive Supreme Court judgments on this issue. Now, the first thing to be noted, as I say before, is that even when the nationalist leaders were at the helm of affairs and when the constitution was being framed, it is surprising that the word sedition was brought in as a restriction to Section 19(1)A. And that was very surprising because when the nationalist leaders were themselves at the receiving end of 124A, that was the first section which should have gone in any case, and it should not have been used as a restriction. But it was. And it led to a hue and cry in the Constituent Assembly debates. When the draft came up, the draft by the drafting subcommittee, then Iyengar, who was there, heavily criticized putting in sedition as one of the grounds for restriction of freedom of speech. And he stated, and I quote, "If we find that the government for the time being has a knack of entrenching itself, however bad its administration might be, it might be the fundamental right of every citizen in the country to overthrow that government without violence by persuading the people by exposing its fault in the administration, its method of working, and so on. We had therefore approved of the amendment that the word sedition ought to be removed, except in cases where the entire state itself is sought to be overthrown or undermined by force or otherwise, leading to public disorder. But any attack on the government itself ought not to be made an offense under the law. We have gained that freedom and we have ensured that no government could possibly entrench itself unless the speeches lead to an overthrow of the state altogether." Now, before I dive further into this aspect of of how the courts have interpreted sedition and then how it has still led to misuse. Just a brief, quick, light touch on why sedition is important as a freedom of speech and expression, which it protects. And the main idea which underlies this is John Stuart Mill's concept of free exchange of ideas, that if there is freedom of speech and expression, there'll be free exchange of ideas. It will lead to an understanding of the truth. And what Justice Holmes very elegantly put it as a marketplace of ideas. So a marketplace of ideas, and which, when they clash with each other, lead to an understanding and finding of the truth. And an interesting formulation of this has been the Supreme Court in the Amish Devgan case recently in 2021, in which Justice Khanna, who's none other than the nephew of the iconic Justice H.R. Khanna, held that George Bernard Shaw has said that our whole theory of freedom of speech and opinion for all citizens rests not on the assumption that everybody is right, but on the certainty that everybody was wrong on some point on which somebody else was right, so that there was a public danger in allowing anybody to go unheard. Many so-called truths have been rectified and corrected because they were disputed scientifically or economically, socially, and politically. Nevertheless, in many ways, free speech has empowered those who were marginalized and discriminated, and thus it would be wholly incorrect and a mistake to assume that free speech is an elite concept and an indulgence. So that's the basis and the fulcrum, and I don't want to go further on this because you're all law students from a very premier law college. I don't need to really delve further on it. Prior to Kedarnath, you had, of course, the Tara Singh Gopichand case, which held Section 124A to be unconstitutional. This was prior to the First Amendment of the Constitution. And it says that a law of sedition thought necessary during a period of foreign rule has become inappropriate by the very nature of change which has come abroad. Now we come to when the First Amendment Bill was introduced. And as I pointed out, just like you had the Solicitor General, of course, the world of difference between Nehru and the Solicitor General, but I'm saying that before the court, as he said that we want to get rid of this case, exactly what Nehru said. Now, so far as I am concerned, this was when the Amendment Bill was introduced, the First Amendment Bill in 1951. Now, so far as I am concerned, that particular section is highly objectionable and obnoxious, and it should have no place, both for practical and historical reasons, if you like, in any body of laws that we might pass. The sooner we get rid of it, the better. We might deal with that matter in other ways, in more limited ways, as every other country does. But that particular thing, as it is, should have no place, because all of us have had enough experience of it in a variety of ways. And apart from the logic of the situation, our urges are against it. Now, despite the above, you have a number of cases which come about during that regime in the 1950s, in which there is misuse of sorts of Section 124A. You have the famous Ram Manohar Lohia case, where Lohia said that you should not pay taxes. And that was a 124, of course, not 124A there. It was the UP Special Powers Act was imposed, but of a similar nature, that you're trying to undermine the state authority, etc. And there, a very important test was laid down, which I think is important even for 124A, which was the proximate cause test. And it said that there must be a reasonable nexus between the effect and what you're propagating. And I think that is the heart of the debate which takes place, which has been elegantly also put forward by one of your visiting professors, Mr. Gautam Bhatia, in his book on this, where he has gone on this issue of the need for the proximate cause test. So in any case, Manohar Lohia case, it was removed. Then there was the Devi Soren case, where at an annual conference which was criticizing the government, a separate state or region of Jharkhand was asked for. Today you have a separate state of Jharkhand, it was asked for. A case of 124A was put there, it was rejected by the court. There was the Sangolsem case, in which a demand was made in a public meeting to ask for a buffer state of Manipur under the aegis of the United Nations. The Manipur High Court there held that, again here 124A was put by the government. 124A was partly unconstitutional to the extent that it sought to impose restrictions on freedom of speech insofar as a speech merely excites or tends to excite disaffection against the government. Then there is the Ram Nandan case, where Ram Nandan, an agricultural labor activist who had accused the Congress government of failing to address extreme poverty in the state and encouraged the cultivators to form an army and overthrow the government itself, was charged with Section 124A. In that, the Allahabad High Court held Section 124A to be void as well. The court held that the mere possibility of a public disorder is not enough to justify restriction on fundamental right of freedom of speech and expression. You have the Gangadhar case in 1960, in which there was a person who in the head of a rally made slogans saying Godse Aapte Zindabad and Bhagwan Godse ki Jai. Now 124A was put there. Court rejected that argument as far-fetched, and it was argued and therefore it was set aside. So therefore, it could be argued that though at the time of the Constituent Assembly, when the Constituent Assembly was sitting, there were large-scale communal riots which were going on. There were vociferous tendencies which were there. There could have been a apprehension by people who are at the helm of affairs that there should be power and centralization which should be kept intact, and the status quo should not be shaken easily. In fact, this is what happened even when the Russian Revolution took place, and Lenin propounded this concept of democratic centralism. But they said that because there are so many nations which are attacking us, we need to have power at the center. That is understandable during the Constituent Assembly debates. But to say that this can continue on even once democracy is established and thriving, that is an anachronism, and it therefore becomes an archaic provision. Well-established proposition that a provision which is not unconstitutional initially, though it was even at that time, can subsequently, by passage of time, be held to be unconstitutional. So therefore, it is even at that time, as I said, regime, just to sum up, in Nehru's regime, one of the most liberal governments which were there, but yet where there were a number of instances of misuse which took place. So when the power is there, it is to be misused. Now we come to the Kedarnath case. Again, the Kedarnath case, I'm sure all of you must have gone through it, so I'm not going to be going into detail. The main thing which I want to point out are two passages from Kedarnath. It came to this tendency to excite disaffection, violence, etc. It is this idea of tendency, when it says that if a speech has a tendency to do that, is what is problematic. Because tendency can be very subjective. What, according to one, can be a tendency to excite or will incite can be very different from another. And this is where the mischief comes in. So what the Kedarnath case did was, it held as follows, just two passages I'll put. It stated that government established by law, he made a distinction between government established by law is the visible symbol of the state. The very existence of the state will be in jeopardy if the government established by law is subverted. Hence, the continued existence of the government established by law is an essential condition of the stability of the state. That is why sedition as offense in Section 124 has been characterized. It comes under Chapter 6 relating to offenses under the state. Hence, any acts within the meaning of 124A which have the effect of subverting the government by bringing that government into contempt or hatred or creating disaffection against it would be within the penal statute because of feeling of disloyalty to the government established by law or enmity to it imports the idea of tendency to public disorder by the use of actual violence or incitement to violence. Court also tried to strike a balance with free speech of the citizen, and it says that the security of the state depends upon the maintenance of law and order, which is the very basic consideration upon which legislation with view to punishing offense against the state is undertaken. Such a legislation has on the one hand fully to protect and guarantee the freedom of speech and expression, which is a sine qua non of a democratic form of government. But freedom has to be guarded against becoming a license for vilification and condemnation of government established by law in words which incite violence or have the tendency to create public disorder. Citizen has a right to say or write whatever he likes about the government or its measures by way of criticism or comment, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. Again, two words, intention, tendency, these are all problematic words. And it is this problem which has therefore continued. This is despite the fact that there were certain progressive rulings also subsequently. But before I go to that, I would like to quote in extenso the Brandenburg case, because that very beautifully brings out why the proximate test was so important. And of course, I'm going to say even with the proximate test today, let's not leave it at proximate. The section has to go. The Supreme Court has lost a historic opportunity, according to me. So coming to the Brandenburg case, I want to point out a few paragraphs. It was a case where the Ku Klux Klan invited reporters and said that we are going to take vengeance against the state if necessary, and we may need to overthrow the state. And in that context, when this case came up before the in the what is so-called Brandenburg case, certain important paragraphs which I want to read out. And it was stated, the question in every case is whether the words used are in such circumstances and are of such a nature as to create a clear and present danger that will bring about the substantive evils that the Congress has a right to prevent. It is a question of proximity and degree. The court observed World War I case put the gloss of clear and present danger on the First Amendment, which is protecting free speech in America. Whether war power, the greatest leveler of them all, is adequate to sustain the doctrine is debatable. The dissents in Abraham, Schaeffer, and Pierce show how easily clear and present danger is manipulated to crush what Brandeis calls the fundamental right of free men to strive for better conditions through new legislations and new institutions by argument and discourse, even in times of war. Though I doubt if the clear and present danger is congenial to the First Amendment in times of a declared war, I am certain it is not reconcilable with the First Amendment in the days of peace. So it doubts even in the times of war whether it is there or not. Then we come to further, it observed in para 19, Justice Holmes, though formally never abandoning the clear and present danger test, moved closer to the First Amendment ideal when he said in Gitlow, every idea is an incitement. It offers itself for belief, and if believed, it is acted on unless some other belief outweighs it or some failure of energy stifles the movement at its birth. The only difference between the expression of an opinion and an incitement in the narrower sense is the speaker's enthusiasm for the result. Eloquence may set fire to reason, but whatever may be thought of the redundant discourse before us, it had no chance of starting a present conflagration. If in the long run the belief expressed in the proletarian dictatorship are destined to be accepted by the dominant forces of the community, the only meaning of free speech is they should be given their chance and have their way. My view is quite different. I see no place in the regime of First Amendment for any clear and present danger, whether strict and tight, as some would make it, or freewheeling, as Court in Dennis rephrased it. When one reads the opinion closely and sees when and how the clear and present danger has been applied, and made serious only by judges so well. Sorry, can I be heard?
So I think we had lost connection for a
Can I
minute.
be heard? Sorry, I saw the screens go off for some. Okay.
So I
we
think we
on?
had lost connection for a minute, but I think we can hear you now.
Yeah, okay. So again, as I point out in para 26, when one reads the opinion closely and sees when and how the clear and present danger test has been applied, great misgivings are aroused. First, the threats were often loud, but always puny, and made serious only by judges so wedded to status quo that critical analysis made them nervous. Second, the test was so twisted and perverted in Dennis as to make the trial of those teachers of Marxism an all-out political trial, which was part and parcel of the Cold War that has eroded substantial parts of the First Amendment. Action is often a method of expression and within the protection of First Amendment. Suppose his own copy of the Constitution in eloquent protest to a decision of the court, may he be indicted? suppose one rips his own shed, he be in one's belief have long been held to be sanctuaries which government could not invade. Brenblatt is an example of the ease with which the sanctuary can be violated. The lines drawn by the court between the criminal act of being an active communist and the innocent act of being a nominal or inactive communist mark the difference between deep and abiding belief and casual or uncertain belief. But I think that all matters of belief are beyond the reach of subpoenas or the probing of investigators. That is why the invasions of privacy made by investigating committees were notoriously unconstitutional. So why I labored on these paragraphs was that even if you talk about clear and present danger test, what one has to say is that beliefs cannot be interfered with. And if we come to the subsequent formulation in the Shreya Singhal case also, where it said that it leads to an incitement, you have to look at, but the first two, that is discussion and advocacy, are hard solely within 1918. It cannot come under 19.2. Now we come to, of course, there were cases such as the Rangarajan case, Arup Bhuyan case, which tried to bring in a proximate test and said that, yes, it has to be an immediate, it should lead to an immediate incitement, it should lead to immediate violence, etc. But yet, because of the tendency argument which is there in the Kedarnath case, there have been misuse has continued. Now, if you look at the Amish Devgan case, which is in 2021, an extremely erudite judgment which has been there. But the Amish Devgan case also really brings out the schizophrenic approach which the courts have had to this issue. So on one hand, while it also talks about the tendency text, that it should be, if something has a tendency to create, which can be quite vague and subjective, as also the proximate cause test also it mentions, and that explains the problem which is existing. So when Common Cause in 2016 filed a case in the Supreme Court saying you examine all the sedition cases which are there and give directions with regard to it, it really did not have much of an impact, because ultimately again it was a case of tendency, etc., which was there, leaving it vague. You've had some positive cases. You've had the Balwant Singh case where there was Khalistanis shouting slogans, Khalistan Zindabad, just after the assassination of Indira Gandhi, came as close to proximate cause as could be. It was outside a cinema hall. 124A was not held against them, although it was, of course, it was used. There's the Javed Habib case, which says that the Prime Minister or his actions of the government, drawing inference from actions of the government, was against a particular community. Someone had criticized the Prime Minister, not held as seditious. There was the Pankaj Botalia case, which said that you must look at the context in which the speech is made. There was the Sanskar Marathe case, where the court made a distinction between disloyalty to the government as being distinct and different from strong criticism, and the Arun Jaitley case, which held that the critique of a judgment of the Supreme Court does not amount to sedition. It is merely fair criticism. Finally, of course, Shreya Singhal, which I've already mentioned, which talks about, which very eloquently puts forward a clearer understanding of 19.1A and 19.2 relationship. And it says that if it is at the stage of discussion or advocacy, it is solely within 19.1A. If it reaches a level of, it goes to the stage of incitement, that's when 19.2 kicks in. Now, although I've talked about the earlier regimes in which, more liberal regimes in which sedition was misused, but from 2010 onwards till 2020, there's been sharp uprise in sedition cases. A mammoth 65% of approximately 11,000 people charged were implicated after 2014. Of all the sedition cases registered against people for criticizing politicians, 96% were registered after 2014, with 149 derogatory remarks against the Prime Minister and 144 against a particular Chief Minister. There's a report which is by Article 14. There's a think tank which has come out with these statistics. The report also finds that in Uttar Pradesh, 77% of the 115 sedition cases since 2010 were registered over the last 4 years. In 2019, there has been a 165% jump in sedition cases from 35 in 2014, with a total 93 cases registered in 2019. Some of the recent cases of gross abuse are well known. I'll just briefly touch upon them. They are as follows. A sedition case slapped against a 25-year-old M. Salman for not standing up during the national anthem. He was arrested and denied bail. 8,856 people from a village of Tamil Nadu were charged with sedition for protesting against the Kundakulam nuclear power plant. Sedition law has also been used against in 2015 against a Tamil Nadu resident and folk singer when he made a song ridiculing the then Chief Minister Jayalalitha for allegedly profiteering from state-run liquor store at the expense of the poor. Sedition law has also been used against journalists who don't toe the line of the government. And this is not something which is peculiar to the current ruling establishment. For misleading tweets about a farmer's death, for reporting on a rape at Hathras, UP, for publishing news that the Gujarat government might have a change of leadership over poor performance during COVID-19 lockdown, for making remarks about CAA in Assam, blaming government for poor administration on a YouTube, etc., etc. Sedition has been used as a tool to stifle protest and defense quite regularly, particularly in the recent protests which took place in the CAA amendment and the farmers' protests. And of course, when it was equally withdrawn, I need to check, but I think those cases are not being pursued or withdrawn. Of course, now there's a stay. But when closer to the elections, those sedition cases were conveniently withdrawn as far as the farmers' protests were concerned. Sedition charges were slapped on 3,000 people peacefully protesting against CAA at Dhanbad, Jharkhand. Sahitya Academy Award winner Hiren Gohen and political activist Gogoi were also charged with sedition for protesting against the Citizenship Bill of 2019. You've of course got judgments in which where again and again courts have warned, and I'm talking about even lower courts. You have Justice Rana, Justice who has taken some very bold decisions, saying that sedition cannot be invoked merely to minister to the wounded vanity of the government. Now, and of course, there is of course of 49 public figures, Ramachandra Guha, etc., when they complained to the Prime Minister about the growing instances of mob lynching, sedition was put against them. So you can see the rampant misuse which takes place despite progressive judgments of the Supreme Court. And in the Indian context, another reason, so that is one reason why I said, one, irrespective of political ideology, it is being misused. Number two, it is becoming even more rampant now. Any kind of criticism is leading to seditious, a situation of sedition being put against a person. Another additional factor which I'd like to highlight is that in the Indian context, it is compounded by the fact that often the government uses 124 in a very selective manner. And so even though there have been cases where if in a ruling party, a speaker incites a mob, and there is supposedly a case where it led to riots, there is reluctance to do an arrest, which takes place almost immediately in many of the sedition cases. There's a reluctance to even bring about a provision of 124A. Now, this kind of a skewed approach, if it is going to be taken, it is going to harm one more very fundamental aspect, which is fraternity. In fact, fraternity has not been highlighted upon or elaborated upon in many cases up to now. But it has been, in fact, in many speeches, just as Rohinton Nariman has emphasized. It's a very underrated concept, but it is, in fact, a value of the Constitution, which has enabled the unity and integrity of India to stay intact. And therefore, by this selective use, this weaponized use of 124A, it is striking at that brotherhood which we are talking about. The preamble of the Constitution did not contain the expression fraternity. It was later inserted by the drafting community under the chairmanship of Dr. Ambedkar. It was highlighted by him that the need for fraternal concord and goodwill in India was never greater than now, and this particular aim of the new constitution should be emphasized by special mention in the preamble. Because you may kindly note that at that time there was partition, there was horrible communal violence which was taking place. In the din of that violence, it was felt necessary to introduce fraternity in the preamble. It was explained by Dr. Ambedkar that fraternity means a sense of common brotherhood of all Indians, unity and integrity of only be preserved by a spirit of brotherhood. In the also ensures the dignity of the individual and the unity of. Sorry, it got disconnected. Am I back again?
Oh, yes, sir.
As to how corrosive to the spirit of unity and integrity, to brotherhood, can bring about by a selective and weaponized use of Article 124A. So I'd like to conclude by saying that the United Kingdom, which was the country responsible for introducing the provision of sedition in India, removed sedition as an offence along with seditious libel through the Coroners and Justice Act of 2009. The Parliamentary Undersecretary at the Ministry of Justice, Claire Ward, was quoted stating, "Sedition and seditious and defamatory
So I think we lost you again. Could you,
bygone
Anshu, can you hear?
era.
Anshu, can you hear, sir? I think we're losing
No,
you.
I think, yeah. I think just the last part.
Sir, can you hear us? I think we'll need you to repeat because your connection is slightly weak.
I think, yeah, I think it's tough. Just give sir a minute, probably. I think.
Can I be heard now?
Yeah. Yes, sir.
Yes,
Sorry.
we can hear you
Sorry,
now.
sorry.
Yeah.
Yeah. So Claire Ward said, "Sedition and seditious and defamatory libel are arcane offences from a bygone era when freedom of speech and expression once seemed the right it is today. The existence of these obsolete offences in this country had been used by other countries as justification for retention of similar laws, which have been actively used to suppress political dissent and restrict press freedom. Abolishing these offences will allow the UK to take a lead in challenging similar laws in other countries where they are used to suppress free speech. New Zealand has also removed sedition as an offence. Despite such removal, one has not really heard of any incitement leading to overthrow of the government after these provisions have been removed. The court therefore had a very historic opportunity, coming to what came before the Supreme Court, that even though the state said that we are considering it, we are looking into it. That is a very normally a state could have said that to just let go of a hearing which is taking place. I think the Supreme Court ought to have still gone ahead and pushed for deciding the constitutionality, because ultimately, what is sedition? It traces its lineage to the Statute of Westminster of 1275, when the king was considered as the holder of divine right, and anything whether true or false against the king was punishable. The rationale of the judgment, which was the Def Libellis Famosus case, which was the first case during those times, was that a true criticism of the government has a greater capacity to vilify the respect commanded by the government and cause disorder, and therefore needs a higher degree of prohibition. The Supreme Court ought to have sensed that a climate of divine right is prevalent in India today, and therefore a removal of such a provision was imperative. This opportunity was lost. Although the stay of the section gave some measure of comfort, yet the uncertainty and tension remain. One can ill afford such luxuries in these times. And one last point which I'd like to point out, there is the Chinese Ordinance of 1907, which uses the same test of tendency, which is the test which is used in Kedarnath. So if we pride ourselves on one thing above China, which is to say that we promote democracy, etc., as far as sedition is concerned, we are on the same wavelength. And of course, I think the Chinese ordinance has a lower punishment for sedition than we have. With that, I'd like to close my
Uh,
submission. Thank you.
Thank you so much, sir. Thank you so much, sir, for like kind of going about the need and kind of taking us through all of the cases which took and which kind of takes us to where sedition is right now in 2022. We have had a tumultuous history, if I could say, with courts also kind of being unsure, the Constituent Assembly also kind of being hesitant to pass it right now. And currently, with this stay, I think hopefully the Supreme Court will have an opportunity to review this law once more and kind of in order to like figure out its contemporary relevance. And with that, I would just like to use the privilege of a moderator and ask the first question before going to the audience itself. which is that we always see with these cases coming in, the government is always using the argument of national security. And this is not just in sedition, we've seen it even in, the internet shutdown cases, in the Pegasus scandal, the Supreme Court, the government coming in saying that, there are not only influences within the state, but, powers outside. And, sedition is basically overthrowing the government, ensuring that elections don't happen. And India, priding itself to be the largest democracy, kind of, just even corners the Supreme Court in a manner to say that, now we try to manage, or, with Kedarnath also coming in, the kind of constitutional safeguards they try to put to ensure that sedition is upheld. So, sir, my question to you being that, do you think such an argument would stand, and how should the Supreme Court, if it gets the opportunity to do so, in your opinion, kind of react to this argument of national security always being waved on its head?
Yeah, so you see, you're absolutely right. One of the biggest problems which faces the courts today um, is when the government takes this argument of national security, and beyond a point, how much can the court delve into the affidavits to find out what is there? But what I'd like to clarify here is that this is more in the case of PILs and writ petitions and etc., which are filed. So when that happens, say the internet shutdown case, etc., then those are situations where when the state takes this argument of national security and the fact that it is leading to it is in the interest of the nation that it needs to be done, and the courts have to, I feel, have no option but to bite it. The Chardham case recently,
Yeah.
in the context of environment being a situation where the court had to give in, it's very difficult for the court to make out. And obviously, I can understand someone sitting in that position to take a decision like this when it relates to security. But when we are talking about 124A, we are talking about trials taking place in which the state would have to bring in more evidence to be able to make out what led to. But the problem is with the tendency test, it becomes very, very far more easy for the state to make out a case. But in any case, what is there is that because you have a full-scale trial under 124A, you still have an opportunity for the court to go deeper into the issue. But the point is, why should one be subjected? Very, very important aspect of jurisprudence is, why should one be subjected to needless investigation, needless prosecutions, needless? This is the best way to stifle free speech. I mean, an intellectual who's not got resources, huge resources at his command, if he's subjected to a 124A, I mean, it's hell for him. Even defending himself against that kind of thing can crush a lot of dissent. So it becomes ultimately, even if the court were to hold in favor, it's almost a Pyrrhic victory, because for so many years you are under stress and tension, and there are going to be very few who are going to be able to
Break through.
continue with their dissent aggressively with a sedition case hanging on their heads. So that's why I feel that although 124A offers that opportunity, it really in practical circumstances does not offer much support. But you're right that is a very, very important point, and which I think in public interest litigation we'll have to look at. How do we deal with a situation where a government is invoking national security at a drop of a hat?
Yeah.
I think initially the courts were more inclined towards it, but gradually there is a waning, some sort of kind of erosion of, or a wariness of the court to accept this argument of security so easily. But it'll take a lot of time.
Understood, sir. So now we'll be moving on to the questions in the chat box.
Yeah.
So Diksha has asked that in the presence of special laws such as the UAPA, do you think the repeal of sedition laws will ever be truly fruitful?
Sorry, would ever lead to?
So in the presence of laws such as the UAPA, does the repeal of the sedition laws from the penal code, will that possibility ever be fruitful? Because we have other sort of legislations, UAPA, TADA, kind of hanging over our head.
Absolutely, absolutely. And even UAPA again was in 1967. It is not something which has come in at this juncture. But any step forward, it is as Nehru said in one of his speeches. I remember, I don't recall the exact quote, but exact source from where it came. But I remember the vice president once quoting that step by step we have to advance, and therefore you have to take one step at a time. Removing sedition would be an important step forward, according to me, because it has been subject to a lot of misuse, and you can see a lot of it being done here. You can see even not why TADA PMLA being misused to crush all kinds of dissent through all kinds of criminal prosecutions being launched and then being put under the ED. So I mean, it is going attacking politicians in a big way. So there will be those sections, but that still doesn't mean that there's no reason why we should not remove and strive to remove, and why Supreme Court should wait now any longer. Because as I've shown, even the most progressive governments, despite genuinely believing, I'm sure they believed in that, in the fact that it's archaic, but did not really remove it.
Yes. So another question which we have is similar to the lines which you spoke earlier in response to my question, is which we see that the onus is always on the accused, right? If he's slapped with sedition charges, to kind of approach the court, and if he wants to apply for bail in an ongoing case. And usually the accused does not have a lot of money or resources to kind of fight these sedition cases, right? If we see 3,000 people from a village being slapped and kind of being dragged to the trial court for all of these matters, if the sedition law is here to stay, would you kind of recommend, say, shifting the onus, reading the law down, kind of ensuring that even if the court does not want to go ahead with striking it down, some sort of beneficial provisions for the litigants at hand is present? Would there be such
Uh,
a possibility?
you see that the court by itself cannot make that change. I mean, it'll have to be a legislative change if at all anything has to come about. But the point is that the court has the maximum which the court can do has been the proximate thing, which really doesn't help us in practical cases, because it leaves it open for a matter of trial. It's more in the UAPA that the presumption is against you. Here, the still under 124A, the state still has to make out a case. But the point is, as I said, that in making out the case itself, it's so much harassment that it achieves its objective. So I think the court cannot do much in this thing except removing this section or staying it. At least they've stayed it. That's a relief. But I think removal of the section is the way forward.
Understood, sir. So we have one more question, which is from Arnav, which says that, sir, in your opinion, do you think the problem is the law itself, or is the implementation? Because we've spoken at length about, even the misuse and the abuse of law. Do you think as a concept, is it problematic, or like implementation, or both,
It's
particularly
both.
when we talk about?
It would be both, because there are these sections which have to be interpreted, and they are being interpreted in a particular way. And the interpretation also so what happens is there are three levels. One is the section itself, which is talking about this. The explanations in the sections do make it clear that disaffection means what, criticism of government will not be included, etc., etc. But the interpretation of the section has led to a situation where, because of the interpretation, it is being misused in terms of the tendency argument. And even with the proximate cause test, it still leaves it open to the prosecution to misuse the provision. So that being the case, I think removal of the provision is important, because if you don't remove it, this conundrum will continue. Even if the Supreme Court were to clarify the law on sedition and come out with its, if it were to suppose not strike it down, even then there'll be scope left for mischief in the implementation. And as I pointed out, it's an archaic law based on very archaic concepts of divine right. It has no business being there in a progressive constitutional regime.
Understood, sir. So the last question would be looking at the fact that the composition of the Supreme Court is also going to change. We'll have a new Chief Justice being taking over from like the next month onwards. Like, what do you think? Like, even in the legal fraternity and circles, is there a general opinion that sedition law will be kind of scrapped about by, say, future Chief Justices or by courts going to come? Because a lot of judges after retirement, they kind of express their opinion. Even Justice Nariman goes on saying that, oh, sedition should have been scrapped and, should have been kind of like taken down. But what do you think would be your opinion, considering the fact that now the Supreme Court is actually taking up this matter in a case?
No, I think what I feel, the fact that the government said that we are in the process of removing this law meant that the proceeding. I can't comment too much on judicial proceedings, but my hunch would be that the government felt that the court was likely to strike down this provision, and which is why the government took this step. So, but at the same time, I think this is the interim, and we'll have to see how quickly if the Supreme Court can take it up And yes, of course, one always has hope that as and when the matter is finally heard, the Supreme Court will strike it down. But it will depend a lot on circumstances at that stage. What are the stars who's actually hearing the matter? What Holmes called the inarticulate major premise. There are everyone has inclinations, everyone has views which are there, and who genuinely believe that it's a genuinely held views which are there. So a lot will depend on that. But yes, as of now, it seemed that the Supreme Court was inclined to strike it down, or at least gave that indication during the arguments. I was not present in the court, but the fact that they put out this kind of a affidavit would tend to indicate that they were worried, and therefore we hoped, and I think it should happen. So
Understood, sir. So even like with court proceedings and particularly the stance of the government, the Attorney General had said that this law kind of could be retained with some guidelines also which come in, right? We need to have some sort of guidelines, some safeguards, kind of doing like helping, kind of putting all of this into some sort of safety net. So do you think like guidelines would kind of be a solution to such a problem, which such a rampant problem which we are discussing right
you see, guidelines. Well, I don't, to my mind, there is nothing really which comes to my mind where the kind of guidelines which can be imposed. It's an important question. I think it's an important question. We can think about it. But to my mind, immediately there doesn't come any guidelines which can be imposed which can prevent misuse of the provision. Um, when some action needs to be taken, for example, in riots. Let me to give you an example. There are statutory powers of a magistrate to call in the army. He doesn't have to ask anyone. And yet, riot after riot, you will see, and I'm not talking about any riots only recently, I'm talking about riots throughout, you will see. How many times has a magistrate uh, called upon the army? So safeguards would be there, but I would say that there is sufficient provisions already in place. And as I pointed out, UK having removed the sedition law, I have not come across, there has been no overthrow of the UK government with free speech and criticism. And in fact, speech criticism is something which enables you to strengthen your position. Because if you are able to defend yourself and point out the reasons why, it leads you to, as they said, in the marketplace of ideas, it leads you to an understanding of and coming to the truth. And therefore, I don't think putting guidelines, according to me, would prevent, because if when ultimately, you see, also this concept of compensation for malicious prosecutions, etc. Again, it's not very well developed in our country. So public servants, even there, are willing to bite the bullet and take a risk in even violating safeguards and going ahead and doing things, and then later it can be just struck down, or it can be um, uh, the court can come down heavily, but the damage is done. So I don't think guidelines are going to. I
now?
think, according to me, such provisions should not remain, and the quicker they go out of the statute book, the better it is.
So
But
we one
Anshul, would you think of some guidelines? I mean, what would you feel? Are they, or the question person who's asked the question, would you feel? Are there any guidelines we could
So I think
follow?
with an offense like sedition, it's problematic right at the source. Like so, even if guidelines are being enforced now, there will be again cases saying that the guidelines are problematic because if you kind of deal with the offense such as sedition and particularly the phrasing of the statute itself, which is tendency, disaffection, ill will towards the government. Government also meaning, do we mean the government established by law? Certain politicians are also being considered to be the government in picture. All of this just like kind of opens some room for debate and some room for interpretation also. So I think if we kind of hit down at the root and kind of just take it out at the source, probably might be helpful. But just kind of looking at what the Supreme Court has been doing with laws, it's kind of reading it down, kind of putting on committees and committees and trying to ensure that the law stays and the execution and implementation is kind of taken care of. It will be really kind of exciting to see what the Supreme Court does in such matters. And we all know for a fact that the Supreme Court loves to come out with its own guidelines. Might be that instead the guidelines coming from the government, the Supreme Court comes out with its own 10-pointer, 15-pointer guidelines that follow this in like every sedition case. So like from which side do we kind of roll the dice is something very like exciting, which
Yes.
I'm looking forward to. So the last question is kind of even a devil's advocate because we've been going about talking about the negatives. We have Akash who says that do you think is there any sort of positive coming out of sedition law being present, and will the taking out of sedition law kind of hamper the functioning of the Indian body polity, considering the fact that every government, even after independence, kind of retained this provision. Implementation definitely was skewed all around, but the core idea was kept by every single government. So, considering the fact that there might be some positives, do you think that there are any, or it should directly
You
kind
see,
of
the
be?
source, if the source of the provision is the divine right, and if it leads to the fact that you cannot criticize the government, then I don't think I don't see any merit in this situation. If actual violence takes place, there are enough provisions in the IPC to take care of that. So I don't think what is happening is that speech is being linked to actions, and that is a problematic area. And despite the courts trying their best to devise tests by which you can try and link and try and have a situation where you try and find out has the speech led to this kind of a situation, it is very problematic. And that's why in the Brandenburg case I was reading out, where I read those quotes where it says even the clear and present proximate test, even in war times, they would not want to look at it. So I think that we have to keep in mind. So speech and expression, I think it's very, very sacrosanct. As I said, you have only your voice, and ultimately that is the main thing which you can bank upon. So I think that I don't see anything positive in this provision. There are enough, as I said, enough other provisions, and I repeat myself on the UK provision being removed.
Definitely. So, with the end, I would like to thank you, sir, for this talk. And, I think all of us kind of learned something from being here and probably, even kind of enhanced our own sort of opinion and views on sedition. And over to you, Shri.
Like Anshul said, sir, thank you so much for sharing your thoughts on the issue. Thank you so much for entertaining our questions as well. Thank you, Anshul, for moderating the session for us today. I understand that the talk has been beneficial for almost everyone present. We will now be concluding the live stream. I would request Sir and Anshul to stay back for a minute. We'll be taking some pictures for our social media, if that's all right, sir.
Before concluding, I'd like to just comment that I think it's excellent that there's a constitutional law. Of course, I'm sure in other law schools also, but you are doing this because there's a very famous book, Wages of Impunity by Kannabiran, where he talks about lawyers going into commercial law and leaving, forgetting constitutional law, etc. I think that needs to be balance needs to be there, and I think this is excellent that this kind of work is going on.
So I'll just request somebody from the team. So if Simran or Suvaru could take some pictures, and then we'll conclude the stream.
Yeah. Do I smile or keep it?
That's up to you, sir. Right, so I think we're done. I'll end the broadcast now. Thank you so much for everyone.
And
Thank you.
hopefully, NUJS can invite us back for a physical talk also,
Of course, sir.
Yeah,
considering all of.
I'm a Bengali and I always love coming to Calcutta, so any day.
Of course.
Definitely.